in person with her client, Bradley Belial Oyat. We have Emma Hanu in person with her client, Dominique Fleckner. We're set today in these matters for preliminary hearings. Are they proceeding as such?
Yes. Yes, Your Honor.
All right. Mr. Vila, this is a joint hearing because these are co-defendants. So please call your first witness.
State calls Captain Julie Mead.
Captain Mead, please come forward, raise your right hand, and be sworn in.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do. You may begin.
Could you please state and spell your name?
Julie Mead, M-E-A-D,
And how are you currently employed?
Captain for the Burnett County Sheriff's Office,
And how long have you been so employed?
25 years.
Prior to today's hearing, did you review criminal complaints as they relate to Burnett County cases 25 CF 150 and 25 CF 151 in the matters relating to Dominique Fleckner and Bradley Belial?
I did.
Did law enforcement execute a search warrant at a residence at 648 Nelson
Your Honor, I'm going to
Street?
object to her testimony. If the only knowledge she has is that she read criminal complaints, that doesn't satisfy the personal knowledge requirement. Hearsay is allowed, but that doesn't mean all the other rules of evidence go out the window at a preliminary hearing.
Hearsay is allowed. You can object if there's hearsay upon hearsay. But in order for her to, she's allowed to testify as to what she reads and provide hearsay. She doesn't necessarily need personal knowledge. Objection noted, but overruled.
Did law enforcement execute a search warrant at that residence at 648 Nelson Street North in the village of Grantsburg?
They did.
Is that area located in Burnett County?
Yes.
Did law enforcement make contact with anyone at the residence?
Yes, they made contact with Bradley Belial.
And how was Mr. Belial identified?
Personal knowledge of the officers that was there.
And did you review any booking photos of Mr. Belial prior to today's hearing?
I did.
Could you please ID Mr. Belial by where he's sitting and what he's wearing?
Yep, he's sitting next to Miss Landgraf at the defense table, wearing a jacket.
Let the record reflect that Captain Mead has identified Mr. Belial, otherwise known as Oyat. Mr. Vila,
Yes,
I'm going
sir.
to ask you kindly to slow down.
Yes, thank you, Judge. Does anyone else reside at the residence?
Yes.
Who resides there?
Dominique Fleckner, and then the residence owner, Rita Wenzel, periodically.
Did law enforcement make contact with Ms. Fleckner?
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a routine preliminary hearing is quickly becoming much more complicated. Prosecutors are trying to establish probable cause against two co-defendants, while the defense is already challenging how the evidence is being presented. Remember, at this stage, the judge isn't deciding guilt or innocence, only whether enough evidence exists for the case to continue. Keep an eye on how every piece of evidence is connected to each defendant, because that distinction could become extremely important later. Do you think the prosecution has enough to move this case forward, or is the defense already exposing weaknesses?
They did. They actually made contact with her prior to the execution of the warrant.
And how was she identified?
Prior law enforcement knowledge.
And prior to today's hearing, did you review any booking photos for Ms. Fleckner?
I did.
Could you please ID Ms. Fleckner by where she's sitting and what she's wearing?
Yes, Ms. Fleckner is sitting at the defense table, also wearing a jacket, black jacket.
The record reflect that Captain Mead has identified Ms. Fleckner.
Was the house at 648 Nelson Street searched?
Yes, it was.
What was found?
In the living room, officers located a purse containing Ms. Fleckner's driver's license and other identification cards, health insurance information for kids. Inside that purse was also a baggie, field tested positive for marijuana, weighed at 1.14 grams. and a, excuse me, a metal smoking device that also field tested positive for marijuana. In one of the bedrooms, later identified by the kids as dad's bedroom, a baggie of crystalline substance was located. That was also later field tested positive for methamphetamines.
Does Ms. Fleckner have any prior convictions for possession of THC?
Yes.
And what county was it in?
I'm not sure. I believe it was Burnett.
Uh,
I believe that would be outside the scope of her knowledge.
yeah, I believe so. No further questions, Your Honor.
All right, thank you. Ms. Landgraf?
Did you take part of this in the search?
I did not.
Do you know anything about this incident other than what you've read in the criminal complaint?
No.
No questions.
All right, Ms. Hanu?
I apologize. Everything glitch. If you can't hear me or understand me, let me know. Sometimes I mumble a little bit, and I like to tell people before that. Based on your review of the reports, Ms. Fleckner was not at the residence at the time the search warrant was served.
Correct.
And at the time that law enforcement made contact with her, they did not perform a search of her.
Correct.
And later, law enforcement interviewed both of Ms. Fleckner's children.
Correct.
Neither of those children identified the methamphetamine as being Ms. Fleckner's.
For the record, how old are the children?
I don't know. They're 7 and 10, Your Honor.
Thank you.
I don't believe so.
I have no further questions, Your Honor.
All right, redirect.
Ms. Fleckner does reside at the residence, correct?
Correct.
No further questions, Your Honor.
All right, additional questions from either counsel? Okay, you may step down. Thank you. Any arguments from defense?
Not for today's purposes.
No, Your Honor, just one note of correction. I don't believe Rita Wenzel lives at the residence.
Okay. Or a bind over, I don't think that is relevant or necessary. However, thank you for the update. Based upon the testimony of Captain Meade, the court will find that felony was probably committed by the defendants in this matter. The court must look at the evidence in the light most favorable to the state. So I do find the probable cause and bind the matters over.
That is a major turning point in this hearing. By finding probable cause, the judge is not declaring either defendant guilty. Instead, the court has determined that the prosecution presented enough evidence for the criminal cases to proceed to the next stage. This is one of the biggest misconceptions people have about preliminary hearings. The burden of proof here is much lower than it is at trial. Even though the defense highlighted potential weaknesses and questioned ownership of the alleged drugs, the judge viewed the evidence in the light most favorable to the state, which is exactly what the law requires at this stage. If you were sitting in that courtroom, would you have expected the judge to make a different decision?
Informations.
Thank you, Your Honor. I'm going through and filing the informations for both cases. Right now, they will mirror the criminal complaint in both instances.
Proceed with arraignments today or set for another day.
Can we just have a second?
You may.
So we can go ahead and not keep the case on the case study. And then we can set our status time. And it's pretty sure it's probably not gonna be really good. So we just take care of that section. And then, wait, we have to just like, just find it.
Excuse me.
We're ready to proceed with arraignment.
They mirror the criminal criminal complaints. Ms. Landgraf, does Mr. Belial yet understand the allegations and the maximum penalties?
He does. We'd waive a formal reading, enter not guilty pleas to all counts.
Not guilty pleas will be entered on your behalf on all counts. Ms. Hanu, as to Ms. Fleckner,
Yes, Your Honor, she's aware of the maximum possible penalties of both charges. We would waive formal reading and enter not guilty.
not guilty pleas will be entered on her behalf. She is entitled to a jury trial, would be entitled to a speedy trial should she request one. Has an offer already been presented prelim?
Yes, for both co-defendants, offers were communicated, but an updated offer does need to be communicated to Attorney Landgraf or Mr. Belial.
Updated offer.
The updated offer, it's going to kind of depend on what kind of treatment he's willing to do so that we can enter in those negotiations. I just need to schedule a phone call with her so we can hash out those details.
Okay, so it depends on whether or not he wishes to engage in treatment
Correct, Your Honor.
and what type.
Some kind of AODA, some kind of,
It was a question.
oh,
And what type, question mark?
yes, it's going to be AODA and follow through, or if he does some kind of inpatient treatment regarding to potential drug abuse issues, I'd be willing to do something substantially different than what I offered.
All right. And there's another open matter, confidential matter. Did you take that into account?
Yes, that's why I received new information from the department. That's part of the reason why I'm updating these offers.
Excellent. All right. Thank you. We can get a status conference set. I don't have a time. I'm gonna try and set it on our permanency plan date, but I don't have a time. We're coming back. Holy cow, it's way out there. March 30th. And I could do anytime between 9 and 10. Oh, actually, or I could do after that too. I could do 10:45 and on.
Your Honor, I'm sorry, I missed the date.
March 30th.
That works for me.
Okay. So does March 30th at 10:45 work?
Yep.
Okay, thank you. March 30th at 10:45. We will see you then. We are adjourned. We will go on the record in the matter 25 TR 775, 25 TR 1015, State of Wisconsin versus Mark Chanel. The state appears through District Attorney Kevin Schmidt in person. We have Mark Chanel appearing in person. We're set today in this matter for a status conference. All right, I was just looking, there are other cross-referenced things. I was just pulling up. And we have 26 TR 378, the refusal for the test. All right. So the court will also call 26 TR 378. County of Burnett versus Mark Chanel. Mr. Chanel is in person, the state through District Attorney Kevin Schmidt. So a status conference, Mr. Chanel, you were provided an ability to speak with one of our top OWI attorneys here in this area, and as I said, probably the state as well. And he graciously agreed to do that and to give you some information. So where are we with this matter? And I know, Mr. Schmidt, this is not your case, but you should have some notes or have an idea of where Mr. Belay is going with the matter. So Mr. Schnell, update the court.
Your Honor, in an earlier hearing, the state represented on the record that they were not pursuing refusal charges, right? Or I can get the transcripts, but
I believe that they said they won't if an agreement is reached and they'll deem the refusal reasonable. If I'm recalling correctly.
oh, well, I can get the transcripts. I don't believe that. I think it was different. They now added that charge approximately over 8 months after the arrest. This late addition creates unfair surprise and prejudice to my defense. I respectfully move to dismiss the refusal charge.
Mr. Smith.
The citations for those get processed in that manner. It's not even a charge. It's an administrative hearing that results in revocation of the license.
And there's a statute of limitations which allows, even if, let's say you commit a burglary a year or 2 years ago, there's a thing called statute of limitations, which would allow them to still file 2 years later for certain things. And this is a refusal. And so with the refusal, there's an ability, there's a length of time that they can file additional citations or forfeitures such as this refusal. And so I don't have any indication that this was done outside of the time limits. And I do believe, I recall that, and again, it's just what I recall. If you're going to order a transcript, that's great. And then you can let me know exactly what was said at the time. But I recall Mr. Valet stating that they could file a refusal, but they won't file the refusal. They will deem it reasonable if an agreement is reached. Some words along that line. But I can't give you the exact words because I don't recall exactly word for word what happened.
Not exact, but yes.
So that's denied, at least at this time. If you find out something else, you can renew your request.
Thank you. And then can I file updated motions right now?
What motions are you trying to file or would like to file?
Updated for the stop more pronounced and the refusal of a second blood test and other things.
We've already addressed those. They've already been denied.
There's more evidence I found on the videos I got last time.
So you're asking for reconsideration of the court with its decision?
Yes, for reconsideration for the new updated information I got from the videos I got last time I was in court.
Okay, that's one reason the court can allow an additional filing for a motion for reconsideration because additional evidence or facts were discovered. And they could not have been discovered at the time of the motion that was filed. So you would be able to file that. I can't make any ruling or decision on that right now because A, I don't have them to read and review, and B, there's something called notice that has to be provided, and the state needs to be provided at least 5 business days notice. Okay?
Yeah, I'm just, I'm asking, can I submit them right now?
What you would need to do, yes, you can bring them up to Amy, our clerk, and she can take them and she will make sure that they are filed.
Thank you.
Okay, so you bring it right now.
We don't need
Copy
one. We're
for
going
him.
to file
You
it.
don't need to give him a copy because if you file something, that means it goes into our electronic system. And if you're an electronic filer, you would get automatically the notice saying this has been filed and you can pull up the document. He will get the ability to get that right as soon as she files it. It'll go into the electronic file and it'll be sent right to him. But I appreciate you trying to give him a copy today.
Okay.
This one is defendant's motion to dismiss refusal charge.
There's,
That one was done on the record, so you can't file that one because we just heard that one. Again, if you get additional information, if you order the transcript and something's completely different than what I had recalled, or something else that you noticed that would help support that from the transcript, then you can file, again, it would be a motion for reconsideration.
Okay.
Okay? And I'm not giving you legal advice, I'm just telling what the
Right.
law is in the process, okay?
Thank you.
So what else? What else?
I didn't, even- what else for what?
I guess, is that the status? There's nothing else going on in the case? You've had no further discussion with the assistant district attorney that this matter is going to proceed to the final pretrial on July 23rd?
Yes, I still have a few things to get to file these, but yes, for the,
Wait, what? You have a few things to
to
file?
get, to get the transcripts. So
And here's the deal. I'm gonna tell you, we don't have much time to file or to find a date for a hearing on this. And I just wanna let you know, you have to give the court reporter written notice that you're requesting a transcript, and then she'll have to make the assessment and tell you how much it would be, and then you would have to prepay her. If she needs to do it, I believe it's within a week's time or 10 days or something of that nature, there's a higher cost. And so I will try to find a date that gives her enough time to be able to do and prepare the transcript, and without having it cost a lot more money for you.
Yeah,
But I can't guarantee that. I'm going to look right now because our final pre-trial's on July 23rd. Okay? Because we have to now get
2
a
months
motion date for a hearing date, okay?
for the
For
refusal.
the things you filed.
Right.
Unfortunately for Mr. Vila, Mr. Schmidt, I have to set it on a your week. So he's just gonna have to make sure that he can make that work. Oh, but it says only one DA.
And he's got vacation coming
He
up.
cannot because he's on vacation, because this is not Mr. Schmidt's case, this is Mr. Vila's case. And so he's gonna need to be here. Oy, oy, oy. It's gonna be a little difficult to try and find a date. But I will do my best.
That June 23rd, we're not actually thinking that OWL is going to trial,
That's what
are
I
we?
was just looking at. For the, my gut says that is not going to be a trial. So I could do June 23rd.
Right.
All right, so do you work, Mr. Chanel?
I work weekends at Northwest Passage.
Excellent. Okay, so this won't impact anything. I'm not sure exactly how long this will take. Maybe an hour? Why don't we do 9 o'clock? Does that work? 9 to 10?
9 AM.
Does that work?
Is this for the refusal?
Not for the refusal. For the two motions you just filed for
One motion, because I could,
one motion, for reconsideration.
Right.
Okay? The refusal, again, that's denied.
Okay.
And now looking at the court record, you never filed, and we went over this before, you never filed within 10 days of a refusal. You must file a request for a refusal hearing with the court. And you've never done that. And it's within 10 days of the refusal of getting that notice citation. You did file something with the Department of Motor Vehicles, the DMV, not the court. We've went over this before, that we're two separate entities. You have to file one with the Department of Motor Vehicles and one separate one with the court. You've never filed one with the court
for the refusal?
or the refusal.
The first time they gave it to me was the 22nd of this month.
No, you get that with your ticket. You get that with the officer when he says you're refusing and you have to go give a blood draw. That's when it starts tick-tocking. Okay, you have 10 days from when you get the ticket that says, here's your refusal. Or they go and they get a warrant. So,
Right.
and I look at the warrant and I sign the blood because you've refused. So that would be, you would have 10 days. Just wait.
Just filed it.
Oh, they
so it
just
says
filed
the
it.
May 20th date.
So 10 days from when it was filed, you're right. So it's 10 days within when it's filed, okay?
It's not 10 days from when it's filed. It's 10 days from the refusal itself when they say it.
That's what I thought, but because you get the ticket, you get the thing, was my understanding. Why don't we just pop right up the statute?
I got part of it here.
Yeah, you're looking for sub 8, sub 8M of the statute.
Yes. Under Wisconsin statute 343.305, paren 9, paren AM4, you have exactly 10 days from the date of the notice of intent to revoke to file your written request for a refusal hearing. If no request is made, your license is automatically revoked for 30 days after the notice was issued. So when you got that, what's called, you should have got something that says notice of intent to revoke. Okay?
They never sent me that the first day.
It wouldn't be sent to you. It would have been handed to
It
him.
was
Yeah.
not handed to me.
Did you go, I recall I signed a warrant for your blood, right? And they went over the informing the accused document verbatim, right?
They never handed me nothing besides a citation for paperwork.
And it would be on there, and with that, you would have gotten it. Because when you give your blood through a warrant, that's when you get those documents.
Right, the cop never, the only thing I got was the citation. That's the only thing I got,
Okay.
one piece of paper.
Well, that should be somewhere to show something.
Date of the notice is May 20th in the top right-hand corner of the document 1.
Notice of intent to revoke operating privileges.
And Amy texted to confirm she mailed him a copy on Wednesday, May 20th.
Okay, you were mailed a copy, okay? So look in your mail or look through all the mail and look at those things, okay?
Okay. But
Okay, and then do you want to write down that statute? Just so you can know, and
sure.
there should be a pen right up there
I got it.
on a chain. It's 343.305.
Point
Paren
305.
9, so the parentheses and a 9 in there. Paren AM 4. And so read your notice of intent. Hopefully find it, and you look at the dates and you read that statute with it, okay?
Okay.
And then if you find something, as I said again, if you find out any additional information that you believe changes this, you can file again, okay?
All right, thank you.
But make sure you read that statute and you follow the statute. All right, so,
Okay, I have one question.
yes.
For refusal and notice of one of the statutes, I kind of copied just part of it down off the internet. So that's what I have. If a person refuses to take a test under sub 3A, the law enforcement officer shall immediately prepare a notice of intent to revoke by court order under sub 10. But immediately, they didn't do it for 8 months.
And again, I understand, and I don't know what was given to you, what was not, and that's why I'm just telling you, look at your notice of intent to revoke your privileges. Look at all of that information and compare it with the statute,
All right.
okay?
I still have some days.
And then you don't even have to wait for a hearing to file anything. Haven't you filed things before without waiting for the hearing? So if you think that you can or want to file something based upon the statute and the document that you review, do it right away. Don't wait for the hearing, okay?
Yep.
Because if there's some basis there, we'll add that to that other hearing.
All right.
Okay? Anything else?
No, that's it.
Okay, all right. Mr. Schmidt, anything you want to add or you want to say, or just wait for Mr. Vila to get the information and prepare?
I'll defer to Attorney Villard. I don't know much about this case.
Okay, all right. So right now I have June 23rd from 9 to 10. Or 9 to 10:30, whatever. We can take as long as we want. I can block off all morning if we need. Okay?
Right. Thank you.
All right. There's nothing else, then we are adjourned, okay?
All right. Thank you. You're on.
Thank you.
All right. Here's that next court date for you.
This courtroom session showcased two very different legal situations. In the first case, the court concluded that probable cause existed, allowing the criminal charges against both co-defendants to move forward toward the next phase of prosecution. In the second matter, the judge carefully explained procedural rules, filing deadlines, and the legal standards surrounding motions for reconsideration and refusal hearings. Rather than rushing to judgment, the court emphasized following the correct legal process while ensuring both sides had an opportunity to present their arguments. Cases like these are a reminder that courtroom decisions often depend as much on legal procedure as they do on the underlying facts. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and in-depth legal analysis.